One issue that is of interest regarding the multi-factor test is the question of how courts of appeal review the district court on application of the multi-factor test. Now, of course, the norm is that courts will defer to a lower court's findings of fact. But of course, when you have a body of law built up around particular factors and what particular factors mean, you could imagine deference on questions of fact with regard to facts that pertain to the application of the factors, but you can imagine some sort of misapplication of a particular factor. But then what about the question of the ultimate conclusion of the district court as to whether or not there is or is not a likelihood of confusion? And here we get a circuit split, and it's one that is kind of surprising when you look at some of the recent Supreme Court pronouncements about trademark issues. So the 1st, 3rd, 4th, 5th, 7th, 8th, 9th, 10th, and 11th circuits all say that the ultimate question of whether or not there's a likelihood of confusion is a question of fact, and one that is reviewed under a clearly erroneous standard. A few courts, however, say that the ultimate balancing of the factors to determine whether or not there is a likelihood of confusion is in fact a question of law, and this is the 2nd, the 6th, and the federal circuits that take this approach. And you have some recent Supreme Court opinions that really emphasize the idea that trademark law questions are inherently factual. Hana Financial case dealing with the question of tacking, and more recently the Booking.com case dealing with the classification of whether a mark is generic or not. And so in light of the signals that the Supreme Court has given, I think if push were ever to come to shove before the court, they would be inclined to find that the question of whether there's a likelihood of confusion is in fact a question of fact. But for now, we have this persistent circuit split with a majority of the circuit saying that it is a question of fact and a minority saying that it is a question of law. But even in a court that treats the ultimate question as being one of fact, I think that trademark law is one of those bodies of law where there is a good deal of susceptibility to appellate court second guessing when it comes to thinking about what the factual conclusions are. And I think that there's this temptation on the part of courts of appeal insofar as the key question, what do the marks look like, is the kind of thing that an appellate court can look at it for itself and develop a strong feeling, notwithstanding the existence of testimony. But it's not the sort of thing like where you have a lot of demeanor testimony, sort of the classic rationales, whether they are persuasive or not, for why we defer to lower courts in evaluating questions of fact, aren't really necessarily present in the context of trademark cases. So I think that there's a certain temptation for appellate courts to kind of, take a peek or take a little bit of a closer look at the facts than may be the case in other bodies of law, or at the very least in fact findings where evaluation of the demeanor of witnesses may play a greater role. And so I think there's sometimes a bit of a de facto de novo review going on. But in any case, for now, we do have a clear circuit split on what is at least supposed to go on at the appellate level when it comes down to the ultimate question of likelihood of confusion.